The third preliminary objection, which was joined to the merits of the Spanish government, was to the effect that the Belgian government lacked the capacity to submit any claim in respect of wrong done to a Canadian company, even if the shareholders were Belgian. The fourth preliminary objection, which was also joined to the merits, was to the effect that the local remedies available in Spain had not been exhausted. The first issue of the case is, does Belgium have the just standing to exercise diplomatic protection of shareholders in a Canadian company? The second issue of the case is, does Belgium have the right and jurisdiction to bring Spain to court for the actions of a Canadian company?
Alrighty, let's go over first the three general principles of this case. First, the concept of no absolute obligation. Second, the need to distinguish company from shareholder when it comes to municipal laws. And third, the limitation that diplomatic protection can only be exercised by the nation state of the company. Under the first principle, it was noted by the court that when a state admits foreign investments or foreign nationals into its territory, part of this admission includes the protection of the law and assumed obligations, as well as their treatment. This is not absolute, though, for in order to bring a claim arising from the breach of obligation in this case, the state must first establish its right to do. Under the second principle, we highlight the importance of the distinction between a company and a shareholder. The reason for this is because in municipal law, the concept of the company was founded on this specific distinction. In fact, only the company, which was endowed with legal personality, could take action in respect of matters that were corporating. More often than not, when a wrong is done to a company, it prejudices its shareholders. This does not mean, though, that they're both entitled to compensation. Whenever a shareholder's interests are negatively affected by an act against the company, that shareholder only has to go after the company for appropriate action. Any act infringing the company's rights does not carry with it the responsibility towards the shareholders, even if their interests were affected. This was generally accepted by municipal legal systems, which international law had to refer to. Thus, any injury to the shareholders' interests which resulted from an injury to the rights of the company was not enough to base a claim upon. If we follow this line of thought from the second principle to the third, it would aptly explain how diplomatic protection then is only ever exercised by the nation state of the country. So, when it comes to unlawful acts committed against a company representing foreign capital, international law authorizes, as a general rule, the nation state of the company alone to exercise diplomatic protection for the purpose of seeking redress. In fact, no rule of international law expressly conferred such a right on the shareholders' national state. Let's move on to the question on everyone's minds right now. If there's a general rule, there must be exceptions, right? Well, the court did consider the existence of exceptions to the general principles, for without the former, the latter might not essentially take effect as they are the commanding principles. Thus, the court had to first study two key situations. With regards to the first case, in this sort of plot twisty way, it was observed by the court that while Barcelona Traction had lost all its assets in Spain and had been placed in receivership in Canada, it does not entirely mean that the corporate entity of the company had also ceased to exist or that it had lost its capacity to take action. As for the second case, there was an area contention to the facts that the company had been incorporated in Canada, had its registered office in that country, and had its Canadian nationality received general recognition. Not to mention the fact that the Canadian government had also exercised the protection of Barcelona Traction for a number of years. If at any point the Canadian government ceased to act on behalf of Barcelona Traction, it nevertheless retained its capacity to do so, which weirdly the Spanish government had not questioned. Whatever the countenance of the Canadian government may be at any given time, this primal fact could not constitute a justification for the exercise of diplomatic protection. A state could make a claim when investments by its nationals abroad, which form part of its national economic resources, are negatively affected in violation of the right of the state itself to have its nationals enjoy a certain form of treatment. However, in the case at bar, that right can only be born out of a treaty or a special agreement. Neither existed and was in force between Belgium and Spain at that. In the interest of equity, a state should be able to protect its nationals, shareholders in a company which had been the victim of a violation of international law. The court considered that adopting the theory of diplomatic protection of shareholders had some looming repercussions. The court believed that it would open the door to competing claims on the part of the different states, which in turn would create this atmosphere of insecurity in international economic relations. In the case at bar, however, where the company's national state was able to act, the court was not of the opinion that jus standi was conferred to the Belgian government.